Good evening and welcome to our medical negligence module. Unfortunately, we couldn't meet last week because I was not well, and I'm sure that the course administrators related news to you. So we will continue with the second part of our discussions of the theories of liability in medical negligence, medical malpractice. So we will touch on negligence as the primary theory of liability, and we will have a brief consideration of battery and trespass, so that we try to draw the distinction between negligence and that particular species of malpractice. And then we discuss vicarious liability, and also look at the aspect of spirit liability, although spirit liability will be discussed fully in lecture 7. And we also touch on the criminal liability as pertains to medical malpractice. And we will touch on breach of statutory duty. Again, that will also be discussed fully under lecture 4 when we are looking at the res ipsa and also statutory thought, as it were. Then we will discuss new dimensions of medical negligence and malpractice, particularly so where constitutional and human right dimensions have come into the picture, which used not to be the case, but for the institutionalization and entrenchment of human rights, I think in a rights-based culture, it is expected that medical malpractice, medical negligence will also be impacted upon. So we explore that. And we also touch on no fault, no compensation as against the fault-based regime. Then we look at the professional discipline and some pull it all together, some issues of policy and philosophy, and that will conclude our theoretical discussions. So it is pertinent to remember that negligence is the primary theory. In other words, as the name of our module suggests, medical negligence. So if you are talking about liability for malpractice, as far as medicine is concerned, then the principal basis is negligence. As a matter of fact, the law does not impose no perfection. The law, let me just switch on something. The law does not impose perfection. That is to say that it is not expected that healthcare professionals will be perfect, strictly speaking. Of course, they are also human beings, and all human beings are fallible. That notwithstanding, the law imposes reasonable competence. That is to say that as a professional, certain level of care, certain level of skill is expected of you. And our courts have built a certain body of authority drawing upon what pertains originally under English medical law. So we have said before, and it's worth reiterating, that when we talk about negligence as a basis for medical liability, it is pertinent to note that most claims do not allege intentional harm, but a failure to exercise the care and skill the circumstances required. So when something has gone wrong and a claim is being pursued in negligence, it's not so much the complaint that you intentionally inflicted harm. That is not it. So we are not saying that you intentionally inflicted no harm. Rather, the complaint is holding you to accountability that being a professional, you were expected to put up a certain level of conduct. And if you failed in that regard, then you will have to face a claim in negligence. So there are three critical elements. And of course, one of them is given an extension. And that is why we say that you have like the four elements, which are the gist of action in medical negligence. That is to say that to succeed in bringing an action in negligence, you must prove cumulatively, conjunctively, that the defendant owed you a duty of care. That is, a legal obligation of care is owed to the patient. And that the defendant failed below the required standard of care. And for that matter, we say that the defendant has breached the duty of care imposed on him or her by the law. And the third is causation, that the breach of duty of care, in fact, that is factually speaking, and also in law, caused the injury which the plaintiff is complaining of. So you need to establish causation. And the injury is complaining of will sound in compensation, will sound in damage, a loss, which is an actual damage, legally recognized harm resulting from the breach. Now, if these elements are established, then you have made a sustainable case in negligence. So let us keep that in mind. So let's say a few more words about the duty of care, especially for the sake of our friends who do not have previous knowledge in the law. So, talking about duty of care, it is an obligation to take reasonable care, an obligation to take reasonable care to avoid foreseeable harm. Foreseeable harm simply means that a harm which, with the exercise of care, you could have actually anticipated that it will occur if you did not exercise a certain level of care. And that is why we say it's foreseeable. So obligation to take reasonable care to avoid foreseeable harm. So in medicine, it arises because professionals undertake responsibility, as we have said over and over again in our other lectures. and other models. The patients rely on the expertise of the professional, and the treatment which will be provided, no doubt, is inherently risky. Risk to body and life, no doubt about that. When it comes to medical procedures, one, ordinarily speaking, simple error or mistake can make a difference. Whether someone remain alive or someone will be dead, whether someone will have his quality of life, radically change. So that is something serious at stake. And that is why Lord Atkin will tell us what is known as the neighbour principle. In other words, in the case of Donoghue and Stevenson, Lord Atkin was trying to propound a test or a criterion I hope you are hearing me. Can anybody react so that I know that I'm not talking to the wind?
No, yes. I hear you.
All right, all right, all right. Thank you, thank you, and forgive the quality of my voice. I'm still recovering, so sorry. Good. So Lord Atkin in Donoghue and Stevenson was trying to formulate or propound a test or criterion or simply a guideline which would enable us to come to a conclusion as to whether a duty of care existed in a situation or not. And Lord Atkin made the point that whenever situation between a person and another, let's say A and B, is said that B is so closely connected or related to B that if B is doing anything or failing to do anything which would actually affect A by reason of the closeness. In the language you use like proximity. No, proximity, that is closeness. We are not talking about only physical, like geographical. No, not only. It could be geographical, it may not be geographical. Then you have obligation in law to exercise care so as to avoid foreseeable harm. And that is why Lord Atkin used the Samaritan example like in the Bible. What do you say? Like, who's my neighbor? That take a reasonable care to avoid acts or omissions you can reasonably foresee will be likely to injure your neighbor. So, in the Donoghue cases, as you know, there was a ginger beer in a bottle, and the bottle was opaque in the sense that you could not actually see through the bottle. It wasn't translucent, so that if something is inside, you will not be able to see it. Now, this woman bought the ginger beer, which unfortunately contained a decomposed snail, but she didn't see it. And having consumed some amount of the beer, before later on, you'll get to know that there was a decomposed snail in it. And the woman suffered various injuries and reaction and sought to sue the manufacturer. But then, if you look at the law at the time, there was no general recognition of a duty of care. Duty of care was very much, pigeonholed or in small categories. Certain situations, the law has recognized duty of care, but we didn't have like a general organizing principle, which will enable us to say that duty of care just existed just like that, though. So maybe when it comes to road users, yes, the law had recognized it and so on. Now, the woman who bought the ginger beer, yes, if anything at all, will have an action against where she bought the beer from. So the question was, would an action also lie against the manufacturer, the maker of the ginger beer? And the court said, yes, despite the fact that there's no contractual relationship between the woman and the manufacturer, insofar as there was a proximate relationship such that the manufacturer ought to have exercised reasonable care to avoid reasonably foreseeable harm, there was a duty. What did the court mean? If you manufacture things people are going to eat or consume, so long as you've manufactured it for human beings consume it, you don't need to know the specific person who is going to buy it before you exercise a reasonable care to ensure that there is no unwholesome or obnoxious element in what you have prepared. Because you should know that ultimately, a human being is going to consume it. Somebody is going to use it. And that is why the law says that you must then exercise the reasonable care so as to avoid any obnoxious element getting into it, like what happened in that case. So the court said that yes, manufacturers owe duty to consumers wherever injury is reasonably foreseeable. And of course, that principle has been redeveloped over and over again. Those who've done like a full course in law of tort, we've come across the Caparo against the Dickman, where the court will say that yes, the neighbor principle is a principle which enables us to recognize new situations in which a duty of care will be said to be existing. And of course, you look at the cases which have come before our courts, particularly, you all know the Asante Kramo against Attorney General, the case of Chinbuah against Attorney General, this is the 37 case, and the case against the University of Ghana Medical Center, Rich, a lot of cases coming up. In all those cases, they all draw upon the well-established principle that a duty of care can be recognized when it comes to the relationship between a doctor and the patient, or between a patient and a healthcare facility. So the Supreme Court, in various cases, particularly Edward, yes, Kofi Mepra, yes,
Hello,
please, go ahead.
please, I have a question concerning duty of care.
Yes.
So as a doctor or a nurse at the emergency units,
Yes.
when does duty of care start? If a patient is brought in with an ambulance, and then like Charles Emissa's case, if there's no space inside the emergency room and I can accept the patient, if I go and see a patient in the ambulance and then ask them to go ahead after doing my first aid, am I owing the patient a duty of care? And if I see the ambulance and I say, oh, of course, I can see there's no space in the emergency room, so you can't come in. So when does duty of care actually start?
All right, thank you, Dr. Abra. Yeah, so when we talk about duty of care, we are not speaking in general sense. You are speaking in specific senses. That is situational or contextual. Of course, we don't say that a doctor owes a patient, a universal duty of care to ensure that the patient recovers or the patient does not die or so on and so forth. No. In the same vein, we are not saying that as soon as an ambulance come to the hospital, then you, the physician inside the hospital, you owe the patient in the ambulance a duty of care. It will depend upon a number of things. So, for example, if you have represented the facility as being open, and then we have an accident emergency or what they call the casualty and so on, open. Then if somebody comes there, because you have actually made that representation, it's a communication that you're able to receive a patient. And patient who will come through that route, route will actually come in situation of emergency. And then if you fail to actually receive them and treat them, that will be not only just the individual. And that is why in modern times, medical negligence is also gravitating more towards a systemic or systems failure. So institutional as well. So it may not so much be just the individual physician, but then the individual physician will come in. If, for example, you went to the ambulance to try and help the patient, and then despite the fact that you went to the ambulance to try and stabilize the patient, you are still expected to exercise reasonable care and skill and avoid foreseeable harm. In other words, whatever you chose to do within that context, we will still hold you to accountability as to whether you exercise a reasonable care and skill so as to avoid foreseeable harm. Yeah, so Dr. Pratt, that is it.
Thank you.
Yeah. So our Supreme Court, a number of cases, including the Edward Nasser against McVroom, will remind us that the Donoghue and Stevenson has developed over and over again, still remains the position of the law in our country. So, as whether a duty will be imposed or not is very much dependent on all the circumstances. All the circumstances. And here, proximity, as we have indicated, is important. Proximity must exist. And when we say the proximity, as we attempted to explain earlier on, we are not only talking about physical proximity. Of course, it's part of it, but not only that. Proximity simply means that it's a situation between you and the other person such that if you don't exercise a reasonable care, that whatever you're doing or meeting to do should not affect that person and it causes harm, then there was a duty of care which the law imposed on you. So that is the kind of proximity we are talking about. And of course, building upon the Caparo and Dickman refinement of Donoghue and Stevenson, our Supreme Court, the Nasser will also say that yes, the court must also consider whether it is just and reasonable to impose a duty. So there are some situations in which we may have to find out whether it was just and reasonable to impose a duty. So let's imagine an ambulance, okay, rushing somebody to the hospital, the nearby hospital, and let's say that he runs into somebody's car. Should we say that the ambulance driver has broken the duty of care? Is there a duty of care between the ambulance and then the other road users, particularly when all the alarms and the siren and everything is on? Is it just and fair to impose a duty in that situation? Now, in healthcare context, the doctor-patient relationship, as we have encountered over and over again, is very important. And when we are talking about a duty of care, we have to remember that a duty arises when a doctor undertakes to diagnose, advise, treat, and then the patient relies on that expertise. Of course, the law does not impose any Good Samaritan principle. If I say Good Samaritan, that is volunteers, you volunteering to do something. No, the law does not imposes any such duty. However, if you decide to do something on the patient, then a duty of care is imposed on you. And this may arise directly or impliedly or through even conduct. So just like, let's suppose that somebody is on his way to the hospital. Let's suppose you are a doctor or you are a nurse or you're a pharmacist or any health professional. Let's take the scenario of outside, Accra, or even outside the regional capitals. Let's say you are in one of the districts. You are walking from your bungalow to the hospital to go and begin your shift. Then, as you are walking, you saw a patient also going to the hospital, and then the patient, for example, collapses, or people are shouting, do something, and then you rush to the scene. And let's suppose that when you got there, you gave a certain medication on you without even bothering to find out whether the patient was hypertensive. And let's suppose that the intervention you gave is something which is absolutely wrong for hypertensive patient. So that the pressure rose astronomically to danger level, and in less than 5 minutes, the patient died. So here, a duty has arisen by you choosing to intervene. you will still be held to the standard which a reasonable, health professional attending to a patient should. So in terms of the existence of duty of care in health care, it's not so much of a difficulty. Again, less in a very typical scenario, a patient comes, a patient takes a card. Once you have signed the patient onto your system, yes, you have assumed responsibility. So a duty of reasonable care still exists between you and the patient. And that duty of care has so many facets. Mind you, if you go to a facility, the patient will go through so many things before he will eventually be entered the consulting room. You go to a place, they check your vitals, they do this, they do that, they do that, they do that. They get to the consulting room. Now, the duty of care does not only start from the consulting room when you are sitting before the doctor. As relates to the hospital and then the respective healthcare professionals, the duty of care actually arises once they assume responsibility over you. Even the person checking your temperature, the phlebotomist who is trying to draw some blood from your vein, he owes a duty of care. The person who is pulling your records owes a duty of care, because if mistakenly wrong records are attributed to you, and that should actually serve as the basis for the treatment which is going to be done, is going to have an adverse impact. And that is why a duty also exists over there. So as you can see, the duty of care extends to diagnosis, treatment, advice, monitoring, referral. If you are referring a patient from your facility to another facility, that referral also entails its own duty of care towards the patient. How you did the referral note, and then a particular targeted institution you are making a referral to, there's a duty of care there. Of course, when it comes to disclosure of risk, there's also a duty of care and confidentiality as well. So as I have indicated, it's not only about the professionals. The health facility, the hospital itself, is an independent duty bearer in terms of the staffing, the caliber of personnel. So those who are into health administration, you should be interested in the quality of those who are hired as professionals to play various roles. Excuse me. Because if you don't take the trouble to find out whether you are hiring competent personnel, you assume a duty of care. Ultimately, the systems which you have in the facility, the equipment, supervision, and patient safety, these are all matters which the hospital as an institution bears duty of care. So if, for example, you allow maybe nurse practitioners or trainees or junior doctors who are still doing their housemanship to run a whole clinic without supervision, without a more experienced senior person being there. And if things should go wrong, it will not be a defense to say that he was just doing what he could in order to save the situation. No, it doesn't really work like that. And the interesting case of a Cassidy against the Ministry of Health, where a patient entered hospital to correct two stiff fingers. And after surgery, his hand was severely disabled. The hospital, of course, was held liable. And Lord Atkin, as master of the rules, that is the present record of English Court of Appeal, will remind us that whenever a hospital accepts a patient, it must use reasonable care and skill. And the reasonable care and skill on the part of the hospital will also include having competent, qualified personnel attending to the patient, because you hire the personnel, you put the equipment there, you put the systems there. Whenever patient safety agreements are there, you are in charge. So you owe the patient a duty of care. And we see this in the Asante Kramo against Attorney General. We see this in the Chinbuah case. All the cases involving, almost all the cases which you have, they don't only go after the doctors, they go after the particular facility in which the alleged Dr. Totfiza was working. Now, the duty of care has been expanding in terms of new areas. For example, when it comes to unborn children, question arises. The health physicians who manage the pregnant mother during the antenatal, during the delivery and all that, do they owe the unborn child a duty of care to ensure that in managing the pregnant mother, they will not be negligent? So there will be no negligent prenatal and obstetric care. If, for example, there was a certain medication or certain intervention which should be given to the mother during the pregnancy, and the doctor or the health team who were managing the antenatal care of the mother failed to do that. And let's suppose that as a result of that failure, it created a certain maybe deformity, some congenital deformity or anything like that later on. Can this child later on sue the hospital and the relevant health professionals? If you have a delayed CS, cesarean section, and as a result of the delayed cesarean section, the mother should die, the baby is delivered, can the baby, for example, later on as an adult or through guardian ad litem, when he grows, even while still under 18, sue the hospital, sue the physician who delayed with the CS, leading to the death of the mother? Or where you insist on vaginal delivery, and let's say that because of the size of the child head or somehow got stuck in the vagina during the pulling out, similar to a little bit like maybe what happened in the Montgomery against the like Nasser scenario. And let's suppose that because of being trapped in the vagina during the delivery or the pullout, he or she experienced the condition of Down syndrome, as it were. Can that give rise to cause of action? So their duty of care. What about genetic counseling failures? So where a mother or even a couple have been attending the hospital before they even decided to conceive. And let's suppose that they had genetic problem, some incompatibility. Particularly, I think the doctor, there's something called the resource factor, isn't it? We have something there called resource factor incompatibility. Is there something like that?
Yeah.
Can you explain it briefly for us?
My lord, I'm not a doctor, but I know about it.
Okay.
Yes, and when someone gets pregnant and then the person has a result, the person is supposed to be administered some injections to prevent something. I don't know. The doctors can.
So doctors, can you explain resource factor and its potential complications for conception for us?
Oh, please, did I hear you say resource factor?
Yes, please. Yes.
Okay, so resource factor simply means that lacking an antibody on the blood cells, on the red blood cells. We have the B, we have the negative and the positive.
Okay.
Now, when there is a absence of a resource positive, there is something we call transfusion reaction, or there is something we call incompatibility. That is when the red cells of the mother get into that of the baby. So when it crosses through the placenta or through the umbilical cord, during separation of the placenta from the baby or cutting through the umbilical cord, and then that of the mother crosses into the child who is born, and the mother didn't receive the resource injection or the de-injection, then it causes hemolysis in this newborn baby, whereby the baby can be jaundiced or having a yellow pigmentation of the eye or the body. So when women are pregnant during antenatal, we do what we call blood grouping, where we will know either the mother lacks that antibody And if indeed the mother lacks it after birth within 72 hours, then the mother must be given resource D injection to just prevent subsequent hemolysis of any newborn. So it is just to guide us that when one gives birth and that injection is not given, then there is a likelihood that that baby may not survive it. So it is only in women. Men don't have anything of that. It is only in women.
Okay.
So that is the most serious aspect of resource incompatibility.
Right. Thank you. Thank you very much for education. Good. Yes. So we also have now these days that we have what they call the genetic screening. There are certain conditions which are genetic, and if there have been proper counseling, maybe certain precautions will be taken in order not for certain unpleasant outcomes to happen in future. So with respect to unborn children, eventually when they are born, can they bring an action in wrongful birth and congenital disability claims? Some of the children who are disabled, some of the disabilities are not really from God, like God want them to come into the world as disabled. No, some are actually due to malpractice during delivery. Some of the disabilities are delivery related, or even sometimes, if not delivery, the kind of medications or certain lifestyle. I know pregnant women who, for example, smokes. If you're a pregnant woman and you smoke, I'm sure that the doctors will agree that it can have certain negative repercussions on the fetus and may even cause some aspect of disability. Is that not the case? Or
Yes, Doc, it is.
okay, yeah. So where all those counseling, for example, were not done, and the child is born, can he bring a cause of action? So those are the matters. And again, we also have the third parties, non-patients exposed to foreseeable danger. For example, when it comes to mental health hospitals, you have a dangerous psychiatric patients, and these patients could cause danger to other people. Of course, as we know, they are not compos mentis, or they don't have sound mind themselves, so they are not in charge of what they are really doing. So is there a duty of care between the facility and third parties? What about contagious disease? When it comes to disease which are very infectious, is there a duty of care? And particularly so when you go to hospital, is there a duty of care? Let's say that for the hospital to put in place good safety systems so that patients who bring contagious disease do not pass it on to other patients who do not have that. And that's...
Doc, please,
Yeah.
this is Rebecca.
Yes, Rebecca.
On that, is that a reason why we
have all the isolation wards in our various hospitals that as much as possible, we have to make sure that we are separating the
Yes.
main wards.
Yes, that is part of it. And there are a lot of things which are done in the hospital, although they do it sometimes as a part of good practices, without actually even appreciating the legal, obligations associated with it. But there are legal aspects, and the legal aspects are what we are discussing now. So it's not just a good arrangement. So, for example, we have go to some hospital, they have a tuberculosis site. Those with the TB, that is where they are, and they visibly label so that if you don't have a TB, you don't go there, so as not to get infected and so on. And also when it comes to even blood, when it comes to blood, they use colors. They use certain colors to signal that there's a high risk, there's this risk, and so on and so forth. And all those things are meant to ensure safety, so that people will also exercise the requisite caution in order not to run into certain problems. Now, what about blood screening? Is there a duty of care? We have the National Blood Bank. When it comes to blood bank, blood transfusion, is there a duty of care? So that if you don't screen the blood properly and you transfuse blood with certain disease or some, not even disease, sometimes incompatibility, cause what they call agglutination. The doctors, there's something they call agglutination. If you have that kind of bad crossing or giving a wrong, so is there a duty of care? Again, relatives. Is a duty of care owed to relatives or patients? So where harm is foreseeable and proximity exists. For example, hereditary risk, communication. Lest some diseases, they run through the family. So that if, for example, you know that a family member of yours or your mother, grandmother, father, whatever, suffered a certain disease or died from certain disease and it's running through the bloodline, please put your mic off. Put your mic off. Wisdom, lock the person's mic. Thank you.
Hello, my lord.
Yes.
Yeah, so when it comes to blood transfusion, there is a duty of care because the lab man there must make sure that there is a compatibility of a blood before giving. For instance, if a patient is A positive, you must ensure that you give A positive or either. Now, in an investigation, when if bloods are incompatible and you do a test called agglutination or Coombs test, you must be able to know that yes, this blood is not compatible. So you don't give that blood to a patient. And in God in his own wisdom, whenever you give such blood which is not compatible, there is something we call rigor. The patient suddenly begins to have rigor.
What?
The transfusion must
begin to have what?
Rigor.
Rigor. Okay.
Come again.
Yes,
rigor.
Okay. Rigor, right.
Yes, my lord. R-I-G-O-R, rigor.
Okay.
Yes. So immediately you negligently give such blood which is not compatible to that of the patient, there is a transfusion reaction onset. So you, the lab technician who cross-matching, or that's something we call grouping and cross-matching.
Yes.
Who did that blood, who cross-matched that blood must ensure that, one, the date of where the blood was transfused or the date of transfusion is noted on the paper, on the badge.
Okay.
The expiring date must also be noted on the same blood. And then the group must also be noted on the blood. So when you take it, you cross-check diligently before you go in ahead to give that blood. So yes, there is a duty of care.
Right, thank you. Again, there's also expansion of the duty of the scope of duty of care towards future patients. Future patients, particularly with respect to record keeping. So if, for example, records of a patient who is related to another family member, and that family member, for example, ran the risk with that patient as actually suffered from some time ago, but because records were not properly kept, that family member who is related, especially this becomes relevant when we are talking about the family physician, where you have like a whole family that actually assess one clinic, and sometimes they are even taken care of by one physician, one doctor. And because it's a family, if records, for example, of members that have experienced certain conditions are properly been kept, others could have benefited from it. Now, having established that there's a duty of care, the plaintiff or the claimant must go another step. That is prove that there has been a breach of the duty of care. And we have said this over and over again. So, with respect to breach of duty of care, the question it seeks to answer is, what would a reasonable, competent professional have done in the circumstances? What would a reasonable, competent professional have done in the circumstances in which the defendant, doctor or health professional, found himself or herself? So it looks at the quality of conduct of the defendant. And for that matter, it's not the bad outcome alone or per se would give rise to negligence. It's not because there has been a bad outcome, there has been an adverse outcome, and for that matter, somebody is liable for negligence. Not necessarily so. We must actually evaluate the conduct of that person against the conduct of a reasonably competent person. I mean, a professional, that is a doctor in that person context. And that is why we know from the well-known case of Bolam against the Ferran Hospital that Justice McNann will tell the jury in his direction to them that a doctor is not negligent if acting in accordance with the practice accepted as proper by a responsible body of medical opinion. In other words, where the doctor acted in line with the practice accepted as proper by responsible medical opinion, responsible body of medical opinion, then that doctor cannot be faulted. That doctor has not done anything which is wrong. And as we know the case of Bolam very well, somebody underwent medical procedure we call the ECT, electroconvulsive therapy, in which they will introduce some electrical shocks as part of a certain treatment. And because of how the shock will affect the body, if you are lying on a bed or table, you could actually come off it. So this particular patient, Bolam, he was not restrained. They didn't apply any relaxant to restrain him so that he doesn't come off. And unfortunately, he dropped off and suffered some fractures. So he sued the doctor and then the hospital. So the question was whether the failure of the doctor to use muscle relaxants, for example, amounted to a breach of duty of care. And it was during that trial that the doctor was also able to line up other doctors to come and testify who were prepared to say that, well, they would not have considered it necessary to have applied muscle relaxants. And that was why, in his direction to the jury, McKnight will tell the members of the jury that men and women of jury, if you go and look at the evidence which have come before the court so far, and you see that what this doctor did is in line with what a responsible body of medical opinion, that is other doctors whose reputation have not been doubted, will have done, then this defendant doctor has not committed any negligence. So that is what became known as like the Bolam test. And the significance of that decision is that it established professional practice as a benchmark for establishing breach of duty of care in medical context. This Bolam test has been followed in many Ghanaian cases, including the Asante Kramo versus the Attorney General, Jan and Asante Gold First Corporation, Dr. Sandy's Abrahamata's case, so many cases. Chinbuah, almost all the cases which are coming up, in one way or the other, they have followed the Bolam test. So, if you look at the cases available in our part of the world, they seem to follow Bolam and say that the test is whether the doctor has been proved guilty of such failure as no doctor of ordinary skill will be guilty if acting with ordinary care. So if the doctor who is the defendant can be demonstrated, can be proven to have behaved in a way which no doctor of ordinary care or skill will behave, then that doctor has breached or broken the duty of care. So if you look at the Jan against the Asante Goldface, we've discussed this over and over again. And the decision was a 2-1 decision, but the majority decision actually followed the Bolam test. And as you remember from the Jan against Asante Goldface Corporation, a nurse made a diagnosis when the child was rushed to the hospital, and the nurse diagnosis was without any reference to a doctor. And the diagnosis was that the child was suffering from malaria and went ahead to inject the child for malaria. When, as a matter of fact, that child was suffering from something of a polio and became paralyzed in the end. Now, when the matter came to court, the court had to find out a senior nurse faced with the situation which this nurse was faced with. Will he or she have behaved in the same way? And the court said that, well, what the nurse did was what most medical practitioners would have done. Seeing the boy or the child with such a temperature, they will have suspected malaria, and that will have been the initial line of treatment. So she followed like the established protocol. And in the court view, the plaintiff had failed to lead evidence of breach of a laid down standards, because what the nurse did was the established standards of protocol. And other professionals who testified said that, yes, that is what ought to have been done. And that is why the court said that, well, then she was not liable for negligence. Now, this thinking in Jan, in Asante Kramo, and so many other Ghanaian cases have also been followed in the recent case of Chinbuah against the Atunjo, that's the 37 hospital. And also,
Please, Azama, Abos, I want to clarify something.
Yes.
Yes, I just want to, about the Bolam principle.
Yes.
Can we say that the core legal principle is negligence is equal to bad conduct, but not bad outcome? Because a bad outcome can happen even with the perfect medical care.
Yes. Yes. I mean, that is true. That is true. Yeah.
Thank you.
Thank you. But again, from our previous lectures and other models, you'll notice that Bolam was decided in 1957, and for over 50 years, it's received various criticism from scholars and other policy observers. And that criticism against the Bolam test of doctrine also made the courts to respond. The courts are also attentive to criticism of established doctrine. No wonder in the case of Bulaito against City and Hackney Health Authority, the court sought to qualify, that is, to limit the scope of applicability of the Bolam test, because the Bolam test had made commentators and critics to say that the courts have actually abdicated their primary obligation of adjudication and oversight, and have blindly deferred to professional opinion, especially medical opinion. So Bulaito came to say that, yes, where the defendant doctor acted in accordance with the body or the respectable body or responsible body of medical opinion, then that defendant's doctor is not liable for negligence. That is true. But then the court said that that expert opinion, that body of opinion, should itself be subjected to some scrutiny, some logical scrutiny, to find out whether the so-called body of opinion is not irrational or unreasonable or does not lack logical basis. If it does, if it cannot withstand logical scrutiny, then the court is entitled to reject the expert opinion, and it will not inure to the benefit of the defendant health professional. And yeah, so I think the most important thing about the Bolito you should remember is that the courts are not bound automatically to accept professional opinion. It must withstand logical analysis. And if you look at our part of the world, another way of embracing Bolito is to say that the facts of each case will determine whether Bolam should be followed or not. So it is the facts of the case, the particular facts of the case before us, which will warrant whether Bolam should be applied or should not be applied. And as we have noted, in 2015, not too long ago, after Bolam had reigned in 1957, and Lord Atkin had failed in Cedar Way to reverse the Bolam test, the House of Lords waited in Bolito, imposed a certain self-censorship as far as the reliance on the Bolam test is concerned. And in 2015, the coup de grace was given to the Bolam test, especially when it comes to the context of disclosure of information and informed consent as a Montgomery against Nasser, as we know very well from last semester. A pregnant woman who was not one of the risks of shoulder dystocia if she did a vaginal delivery because of the size of the child and also her own underlying conditions. Severe injury eventually resulted. And the court was the view that when we talk about material risk, which must be disclosed, it's not a question of a certain percentage. Because if you look at the old cases, even from Cedar Way through up to Bolito, as to whether a risk will have been disclosed to the patient is often calibrated in percentage terms. And that is why the court will say that doctors must rather disclose material risks. And materiality here turns on what a reasonable patient will consider significant. So what would a reasonable patient consider as significant risk to be told concerning a procedure or concerning a treatment? That is what determines materiality. And for that matter, disclosure should be made. And where disclosure is not made, there is a breach of duty of care. So here, it's not so much about what a body of medical opinion will do with respect to disclosure. No. The power has moved from the doctor's perspective to the perspective of the patient, that we are now looking at the patient point of view, a reasonable patient point of view. What would a reasonable patient consider as significant to be disclosed? That is what will guide that there should be a disclosure or not. Now, where, of course, let me say that when we are discussing our next, the next two lectures, or the next, we will come and discuss res ipsa locuto as another aspects of proving breach of duty of care. So we'll look at that, and that is why I have actually been silent on it at this stage. Now, quite apart from the breach of the duty of care, a successful successful plaintiff or claimant in medical negligence must also prove factual causation. And when we talk about factual causation, there is what we know as the Barford test, which we use. So the basic inquiry is that, but for the negligence, would the injury have occurred? In other words, when the plaintiff or the claimant has proven that there was a breach of duty of care, that is not the end of the plaintiff's burden. The plaintiff has another burden. The other burden he has is that he must answer the question, can we say that, but for the negligence of the defendant, the injury that you are complaining of, you will not have suffered it? If the answer is yes, then you have satisfied the requirement of factual causation. So in other words, we are saying that the injury or the harm or the bad outcome, so to speak, which you are complaining of, was factually caused by the failure of the defendant to exercise the requisite care and skill. Now, no doubt, medical causation is not a simple matter for obvious reason. The patient may already be ill. In other words, the patient may be suffering from some other condition. So just imagine a patient who went for an eye surgery, okay? And that patient already has underlying conditions. Maybe he's asthmatic, is diabetic, hypertensive, whatever. Just think of it. Or the person maybe have some either some benign cancer or tumor or something like that. So all these underlying conditions are there. And let's suppose that during the eye surgery, the ophthalmologist Is that the what they call this? Is it the eye surgeons? Doctor, is that how you call the eye surgeons?
Ophthalmologist.
Ophthalmologists. Okay, good. So thank you. So ophthalmologist, for example, did not do something right, and the person's face was deformed, totally changed. Now, it may well be that it's not just what the ophthalmologist, I mean, that's a mouthful word. The person doing the eye surgery, it may not be the case that what he didn't do right, which necessarily has occasioned the bad outcome that you have on hand. The bad outcome might have probably been caused by some of your underlying condition. So that's a challenge. Multiple factors, in this case, may contribute. Uncertainty is often impossible. And that is why we say that medicine deals in what? In probabilities rather than certainties. So if you look at the Barnett against Chelsea and Kensington Hospital, for example, some people had actually taken arsenic poison. They were given arsenic poison. And when they got to the facility, the doctors were negligent in failing to examine them. And the court, with respect to causation, took the view that, yes, the poison itself, if we take arsenic poison itself is fatal. Nobody takes arsenic poison, and then, ordinarily speaking, you survive. Well, there's a miracle. And the failure of the doctors to examine those patients who were suffering from arsenic poison did not cause the death, because the court was the view that even if the doctors had bothered to attend to them, because of the fact that it was arsenic poisoning that they had brought, they were still going to die anyway. So the Bradford test will not be satisfied. We cannot say that but for the failure of the doctor to attend to the patient suffering from arsenic poison, the patient will not have died. Because from the facts, even if there had been that intervention, the death will still have occurred. So the takeaway here is that negligence without causation is not enough. The breach must have actually caused the harm. There should be a nexus. There should be a connection, a link between the breach of the duty of care and the harm or the injury or the bad outcome that you are complaining of. Now, quite apart from factual causation, we also have what we call the legal causation. So,
Doctor,
yes,
it's Abosa.
yes, please.
Yes, my simple question here is that, so could the doctor have been fit for preach, but not the court?
Okay, good, thank you. You see, in the beginning, I made a statement that to succeed in medical negligence, you must prove all the 3 or 4 requirements, depending upon how you count them. You must prove them conjunctively, cumulatively. is not disjunctive, meaning that the breach, the existence of duty of care must be established, the breach of duty of care, and then the causation, and then the damage. They must all be established, except that in reality, you will not have all the four being contentious in a case. In a case, sometimes there may not be dispute as whether a duty of care was owed, or there may not be a dispute as whether there was a breach of duty of care. But the dispute or the controversy may revolve around causation. Whether the breach of the duty of care is what actually caused the injury, the bad outcome which the plaintiff is complaining of. That could be the focus. Please, does that help you?
Yes, sir.
All right.
Because when you look at this case, the doctor admitted that there was a breach of care.
Yes.
But the question was that, would that have caused the death? So I was saying that once the doctor has admitted that there was a breach of duty, but that, and he himself has admitted. So with that admission, is it enough to sue him on that aspect, but not the cause of death?
Good. And that is why I was making the point that if you sue him, you should be able to prove all the elements. You cannot prove only one and expect that to be successful in the case because of the nature of negligence as a cause of action. All the elements must be established, not some. But the point I was making was that in reality, you may have some of the elements which may not be in controversy, which may not be in contention. But that does not mean that it changes the basic proposition that in negligence action, all the elements that what must be established. Please, are you with me?
Yeah, well understood, sir.
All right. Yeah, so we have a legal causation. So even with factual causation, liability may be limited by remoteness and policy. In other words, you may succeed in meeting the Bradford test in saying that yes, but for the negligence, this injury will not have occurred. That is true. We succeeded. That notwithstanding, because of legal policy, you may still not succeed in meeting the requirement of causation. For example, it may well be that they have what we call the novus actus intervenus. So novus actus intervenus simply means that there has been an independent intervening act which breaks the chain of causation. In other words, when the defendants actually breach the duty of care, which you have established, something came between his breach of duty of care and escalation of things for you to get the injury or the bad outcome you're complaining of. And because of that, the doctor or the health professional or the hospital's breach of duty of care may no longer be responsible for the bad outcome or the injury you're complaining of, because an independent intervening act has actually come into the equation to break the chain of causation. So let's suppose that you went to a hospital for a procedure, okay? So let's suppose that you went for a typhoid treatment in the hospital, and you have been given some treatments, and you have finished the course of the medication, which was actually given you. But you go to your local herbalist, or yes, to go and do, let's say, some other herbal treatment. And subsequently, you get certain bad outcome. Now, let's suppose that the hospital or the physician that attended to you were negligent, in the sense that they gave you medication, which is not medication for typhoid, but let's say medication for rheumatism, okay, just as an example. Now, because, and let's say that medication caused you certain situation, but then you go and do some other things. Now, because you've got to do some other things, that may be reckoned as an novus actus intervenus, as an intervening act which breaks the chain of causation, so as to exculpate the original tortfeasor from liability. Sometimes not even subsequent negligent treatment. Even your conduct as a patient. If, for example, you were asked to come for a review in 3 days' time, and it took you 2 months for you to come for a review, and a certain condition has actually developed from the treatment that you were given. But then the treatment, that condition actually developed, let's say, 2 weeks later. And the condition is such that if you are gone back for the review in 3 days' time, the hospital could have actually discovered. The hospital could have discovered the problem and put in place certain measures to arrest it, so as not to let it occur. But because you didn't go, they couldn't detect it. So here, your conduct as a patient in this particular scenario could be treated as novus actus intervenus. That is an intervening act which has broken the chain of what? Causation. Now, we may also have a situation of a complex and multiple causes. So several factors may operate at once. You could have maybe like a disease itself, delay, that is a delay by maybe the healthcare professional or treatment error or lifestyle. So we may have a multiple factors at play. And then when that is the situation, the test is, did the negligence materially contribute to the outcome? In other words, where apart from the negligent act, there are some other factors which all appear to have also interplayed to bring about the worsened outcome, which the plaintiff is complaining of. Then the question is that, assuming the negligence here is delayed diagnosis, the question will be that, can we say that this delayed diagnosis materially contribute to the worsened outcome? In other words, would earlier intervention probably have improved the outcome if there had not been a delay in diagnosis, and then there have been an earlier intervention, treatment, procedures, and so on? Would that have improved the outcome? So that we can say that if that did not occur, then the delay materially contributed to the outcome, so as to make it the most efficient course. Well, we know that we can have situation of scientific uncertainty. That is where it's not pretty straightforward to pinpoint a particular factor as having materially contributed to the outcome. So in that respect, the court rely on expert testimony and also probabilistic reasoning. Look at probabilities. We also have another aspect of causation, that is the loss of chance. Loss of chance. By loss of chance, we are referring to the situation where a patient says that because of, for example, the delayed diagnosis, or because of the delayed treatment and so on, I have been deprived of the chance or the opportunity to have recovered or to have had a better outcome. So if you look at the Hodgson against East Berkshire Area Health Authority, an English case just like Chester and Afshar, a boy's hip injury was negligently misdiagnosed, and that reduced his recovery prospects because there had been wrong, negligent diagnosis. It certainly affected the treatment plan that he should be given. But during the trial, the court held that the plaintiff failed to prove causation because the injury probably would have occurred anyway if you look at all the evidence. And the posture of the court reinforces the strictness of traditional causation and the difficulty of loss of chance claims. The court is not very much amenable to entertaining loss of chance claims unless they are extremely deserving, as it were. Similarly, in Chester and Afshar, a case that we have also discussed over and over again, there was a spinal surgery which was conducted without prior warning to the patient regarding an inherent risk, no possibility of something going wrong. And the risk was 1 to 2%, that something could go wrong with that type of surgery. But the surgeon was silent about it and did not make the disclosure. And unfortunately, the devil reared its ugly head by letting that risk materialize, something which, if you take a 100% situation, only 1% or maximum 2% chance of it happening. And then unfortunately, it actually happened. So the woman, Miss Chester, sued. And the basis of her suit is that if she had been warned that there was a 1 to 2% chance of such injury occurring, she would have sought further advice or alternatives. And because she was not actually warned about that small inherent risk, the 1 to 2%, she had been deprived of the chance to seek further advice or alternatives, and which would probably have actually meant that she would probably not have even run the risk of going through the procedure as it were. So the House of Laws will ask the traditional causation to protect patient autonomy, and some of the laws, laws 10, Hope and Walker, for example, will agree that the factual causation was satisfied, that is the Bradford test was satisfied, on the grounds that, but for Dr. Afshar's failure to inform, Chester, that is Miss Chester, would not have undergone the specific surgery performed. And for that matter, they were liable. I mean, the doctor was liable. That if you had actually informed her, she would have actually decided whether to go for the procedure or to seek an alternative, as it were. I'd like you to read all these cases.
What if the doctor was also looking at the general health benefits of the procedure as against the procedure not being carried out at all?
Good. So, if you look at the case closely, and mind you, this was decided in 2004. So, already, Bolam was losing its favor and its popularity. So, the court was trying to say that the autonomy of the patient is important. It's important, and the patient should be told the risk. It doesn't matter, you're using your superior knowledge as a physician to say that, no, this procedure, but let's look at it. This is the clear evidence here is that, yes, as you rightly said, maybe there's a general benefit, like the benefits outweighs the risk. There's only a risk of 1 to 2%. That is true, you are correct. But here is the case, unfortunately. In the case of Miss Chester, the risk occurred. As the book of Job said, what I feared is what has come upon me. The 1% or the 2%, which we actually thought that, I mean, this is nothing to be worried about, it actually happened. You see how it reinforces the argument for respecting autonomy. If it had not occurred, I mean, there's no problem, and even to not have been a case for us to be discussing. But the fact that it occurred meant that, yes, the patient should be given the opportunity to decide whether she would like to still run the risk or not.
So sometimes, Doc, please, sometimes when we delay procedures, like patients will be booking for procedure, they will go, they will come. The society or maybe some relatives sometimes feel like they are tossing the patient. He's been to the hospital, they are not giving him dates. They are giving him dates that they feel is too much ahead. Could it be that the surgeons or the prescribers are taking their time to go through all these things for the patient to make proper decision with consent to avoid what?
Well, it's what you are
when
giving.
society also they are delaying procedures.
All right, thank you. What you have said is a very generalized situation. So we cannot actually make a general proposition which will apply to every situation. It will have to depend upon like the first of each case by case basis. It may well be that what you said is what is happening. It may also well be that some other things are to be blamed for the delayed. Yes. But it's for us to reflect on these matters as whether it is necessary for us to give more respect to patient autonomy in terms of decision-making or choices regarding treatment, or we should just be very much concerned using our superior technical knowledge as a health professionals to try and impose treatment or procedure in order to avert what, in our professional judgment, we think could be something catastrophic. So I want us to continue to think about that as we journey along. So maybe let's look at the two recent cases by my friend Akabuafo, who was in the High Court. Very interesting cases. The Chinbuah against the Attorney General, and then Ajiri Tete against the University of Ghana. These two cases, they all relate to maternal death. The same judge, but opposite results. There was a success for the plaintiff in one case. There was a failure or disappointment for the plaintiff in what? In another case. So if you take the Chinbuah against the Attorney General, so I have put, let me see, I'm putting that case on your platform. Yeah, I think I put it on a platform. Maybe somebody should confirm if it is there. Is it there?
Yes, it's
yes, okay. I've also put the other case, Ajiri Tete. I think that one should also be there by now. Have you seen Ajiri Tete?
Yes, please.
Okay, good. So, in Chinbuah against Attorney General, it's a case I'm sure you've all followed in the news. The first plaintiff is the father of the deceased. The second plaintiff was the husband of the deceased. and the father of the little infant, Yaonyameche, whose birth resulted in the death of Mrs. Helena Abrema-Nyamiche. Now, according to the plaintiff, the second plaintiff, that is a military officer who at the time of the incident was serving as physiotherapist at 37 Military Hospital, the facility which is at the center of this suit. The plaintiffs plead that until the death of the wife, the deceased was also a PhD student in molecular cell biology at the University of Ghana. So the basic facts are that the deceased and the second plaintiff, they had, of course, the deceased was pregnant, and they had actually contacted the hospital to discuss how delivery and everything will be done. Things did not go as they had. Well, I want you to read the full case. Did not go as they had wanted in terms of like the delivery procedure. With respect to duty of care, there was no dispute that this duty of care was owed to the disease, and for that matter, the little Yaonyameche, and also the surviving spouse, and so on. With respect to breach of duty of care, that was also proven if you look at the full case. And the proof of the breach of duty of care here was interesting in the sense that most of the things the judge relied on were actually admissions and concession by the defendant's own expert witnesses. That is the 37 hospital. They called expert to help them to put up a defense that they had actually not done anything wrong as it were. So there was no problem really with the breach of duty of care. Now, with respect to causation, the court found that untreated vaginal tear and failure to transfuse actually caused the death. I mean, basically, that is what really caused the death in that particular case. There's no doubt the hospital was liable vicariously because it was a hospital that actually employed the physician who negligence led to the death of the mother. I'd like you to read the case, and my Lord Akabuafo, he took his time to actually present as much of the evidence of all the witnesses involved. So it's very rich for our purposes as students of medical negligence. So I'd like you to take your time, just about 49-page decision. Just take your time and then read it. I want everybody to read these two cases and all the cases we cited. When we have our next class, the first few minutes, I do want to call it the case class, and then I will mention your name and be asking you questions about the cases. The facts, the issues, the particular evidence, the court rushing, and so on. So I want you to pay attention and then read the full judgment. And you enjoy reading it because the judge writes very well. So, for example, you look at page 95 of the decision, you come to the issue. The next issue is whether or not the deceased died as a result of a delivery and therefore considered as a maternal mortality. I just quote a portion of the judgment, paragraph 95, quote. The case of the plaintiff is that the deceased death was as a direct result of the vaginal delivery she had to undergo at 37 Military Hospital. The second plaintiff recounted in detail the events that, according to him, led to the death of his wife. He spoke. Can somebody continue from paragraph 95 for us?
Okay, so he spoke of how the deceased BP kept fluctuating all through the night as he kept requesting for frequent checks from the nurses. He stated the readings to be 170 over 110, 160 over 110, 140, 95, 150, 110, etc. He also told the court of the conversation he had with Dr. Ejarijan and the request for the cesarean section and how it was overruled by Dr. Bano and the induction to labor thereafter. He recalled how he stood by his late wife with the consent of the midwives as, quote, as she kept screaming and crying of intense pain, end of quote. To the second plaintiff, therefore, his wife's death was as a result of the pain she was made to go through by the vaginal delivery.
The next paragraph, 96.
96. The court notes and agrees with plaintiff's counsel that the positive testimony from the second plaintiff was never impeached in cross-examination by counsel for the defendant. By a stream of decided cases, it is now a settled rule of law that where a party has given material evidence and that party was not seriously challenged by way of cross-examination and or evidence in rebuttal, that party needed not offer further evidence in support of that fact. The cardinal presumption is that the party against whom the evidence was led admits that fact even in sub silentio. See IRB versus Fori, GLR 627 SC. Should I continue or it's?
I mean that's fine. All of you go and read that. Yes. So please, I'd like all of you to read the case in full. And then the case of Ajiri Tete. So you notice that I will come and discuss the damages later on when we are discussing damages as a topic in the standard lecture. Now in Chinbuah, full damages were awarded, so to speak. Now in Ajiri Tete again, University of Ghana, no similar facts, but the claim was not successful. Again, there was no dispute as to existence of duty of care, but the court held that the breach had not been proven on the evidence. The plaintiff did not call any experts and rely only on online reading. So, in the court's view, the standard of care test, as articulated in the Jan versus Asante Goldfields, of course, Jan and Asante Goldfields did nothing unique than to follow Asante Kramo against Attorney General and also the same undertaking. It's not met. And if you look at the post-mortem examination, it also undermined causation. So the whole claim was not successful. No liability was actually established, as it were. So bringing all this together, what we see is that in terms of malpractice, Negligence is the organizing principle, the common thread, which runs through claims. And we also appreciate that negligence tries to strike a balance between patient protection, medical uncertainty, professional judgment, and healthcare realities, from what you have actually been recounting from the film. And we have also seen that the way negligence has developed or evolved, so to speak, also reflects a shift from paternalism towards autonomy, as we saw in cases like the Chester and Afsha, for example, and also Montgomery and Lagnacher, and also Chinbuah against Attorney General. Because Chinbuah Attorney General, if you go and read it, you'll notice that the couple had actually wanted the CS, cesarean section. But that was not taken seriously. We also see that there's a shift from just focusing on the individual fault of just the physician towards the institution. So institutional responsibility. And you look at all the cases, you notice, especially in the Ghanaian cases, you don't just mention an individual physician. You mention the hospital. The hospital, and then if it's a state hospital, because by virtue of Article 88 and the state proceedings out of at 555, Attorney General is the defendant. Again, we also see that there has been a paradigm shift from the rigid difference towards medical opinion and the medical profession towards judicial scrutiny. If nothing at all, Bolaito told us that if a responsible body of medical opinion cannot withstand logical scrutiny, then the court is at liberty to disregard it. But we'll discuss this further when we are discussing issues of damages in lecture 3, and then the res ipsa loquitur, and the negligence per se, and later on the records and aspects, as well as the matters of procedures relating to medical negligence litigation. As I've told you, there's a book I am working on, which will be launched very soon, but unfortunately couldn't be ready for your class. But you can still get copies for your records. Okay, so just before we go, although we are discussing negligence, it is important for us to remember battery and for that matter trespass to person, so that trespass to the person, so that we're able to draw the distinction. And we should note that before negligence became the dominant paradigm in terms of redressing medical malpractice, we also had battery, that is a trespass to the person, and battery protects the inviolability of the body and the right to determine what is done with it, that every person's body is sacred, and you have sovereignty over your body, so to speak. You decide whether somebody can do something with it or not. So battery addresses intentional interference with bodily integrity. So unlike negligence, there's no requirement for reasonable care. So when we are talking about when we are talking about battery, we are not talking about reasonable care. No, that is in negligence, but in battery we don't talk about that. So battery concerns intentional physical interference without lawful justification or valid consent. And every intervention in the clinical setting involves touching. So consent is central justification for treatment. So without consent, surgery, injection, examination, blood transfusion, procedures, they will all technically constitute battery because they all involve what? Touching. You go to the hospital, the doctor can just hold your hand and open your face. The doctor can just ask you remove your top, bring your breast, put it in your hands, and they'll be examining it. The doctor can say, okay, lie on the bed over there and loose your bed, open your anus, open your genitalia, and things like that. It's all part of examination. Now, every competent adult, as we have met from the Venerable Justice Cardozo, that every competent adult has a right to decide what happens to his or her body because of issues of autonomy, dignity, liberty, and self-determination. And for that matter, even if you are going to do beneficial treatment for a person, it may still be unlawful if it is performed without the person's consent. And that is why, in the case of Substantive against Society of New York Hospital, Cardozo J. will remind us that every human being of adult years and sound mind has a right to determine what shall be done with his own body. So in the Substantive case, the patient consented to examination and anesthesia, but refused surgery, and the surgeons removed a tumor against her wishes. And eventually, the courts, when the matter came before Cardozo J, would affirm the right of every adult or sound mind to determine what is done with his own body. So if the person has not consented to surgery, you cannot do the surgery. The person consented to examination, you have to limit yourself to the examination. There are various types of consent. So we have express consent, that is clearly authorized, either verbally or in writing. Or someone will say that if you go to hospital, you sign up as a patient, you have consented that you'll be touched. Or implied. For example, you open yourself up that they should inject you. That's implied consent. Or certain disclosures are made to you, and then you agree. So that is informed. And then those who cannot decide, they can be substituted consent, as it were. In Ghana, we don't have what you call the lasting power of attorney. So otherwise, some people can donate lasting power of attorney or advanced treatment directives, that if I am not able to decide, then I have empowered this person to decide on my behalf, and so on. Now, consent is also presumed in emergencies where immediate intervention is needed and the patient cannot consent. Consent is also presumed. And that is why for Jehovah's Witnesses, some of them will even carry things on themselves that I don't accept blood transfusion. Of course, subject to the constitutional prescription, as the Constitution will provide. There are parameters within which your decision to refuse transfusion will be respected, but otherwise the Constitution will hold sway. So for consent to be valid, it should be voluntary. That is, nobody should force anybody. It should be informed, it should be given by a competent person, and then it should be specific to the procedure. There's nothing like a general consent. So You don't tell me that you are going to, for example, do procedure A, and then you take that consent as a general approval to you that you should do everything. But this issue come up if you do what we call the laparoscopy exercise. Maybe, for example, a particular issue is suspected and they decided to open up or do some other examination. I don't know whether laser can even do that now. And they see something which is problematic as whether intervention can be made in order to arrest that so as not for it to cause a problem to the patient. Can the patient who has actually consented to such exploratory, if you like, surgery or laparoscopy, as it were, be said to have also agreed that if anything is seen, would need to be dealt with so as not to harm the patient? Can that be done? Yeah, so for incompetent patient, like patient who suffer from disability, minors, and so on, there's what we call the substitute decision making, and the best interest principles and various statutory frameworks, including the Mental Health Act, actually apply as it were. So we will. It's 8:22. We try and finish at 8:30. So what is the difference between negligence and battery then? So battery is intentional interference with bodily integrity without consent. And the wrong here lies in the absence of lawful authorization. In the past, if we look at the history of the common law, battery carried some greater stigma. It's like you have invaded somebody's body, somebody's person, without the person's authority. Now, negligence, on the other hand, consists in failure to exercise reasonable care and skill. So the wrong here, with respect to negligence, lies in substandard professional conduct. So negligence recognizes mistake, misjudgment, and professional error. It's not just absence of lawful authorization. Of course, there will be lawful authorization, but that is not enough. That a certain quality of care is expected. And that is why in Chatterton against Jessen, the court will remind us that once a patient is informed in broad terms of the nature of a procedure and consent, the claim sounds in negligence, not battery. So once a patient has been given general information and the patient has consented, if something goes wrong, you cannot bring an actually battery. That should have to be brought about the negligence, because battery deals with absence of lawful authorization. So if you're giving lawful authorization and something has gone wrong, then your remedy lies in negligence, not in battery.
Lord, kindly come again there. Sorry.
Which one, please? Hello?
Or the negligence. The last summary.
Oh, okay. Then the negligence, I was saying that it deals with failure to exercise reasonable care and skill, whereas battery deals with intentional interference with bodily integrity without consent. And for that matter, where, as happened in Chatterton and Jessen, the court told us that if a patient is informed in broad terms, that is, giving broad information regarding, but of course, if you look at the thinking of the court in Montgomery and Nasser and subsequent cases, it is submitted that the position of the law in Chatterton and Jessen may probably not be a good law, because with respect to the level of disclosure the court talk about, because in Chatterton and Jessen, the court is saying that if you are giving information in broad terms of the nature of the procedure, that suffices. But then this this broad terms information will not suffice in cases like even Chester and Napsa, as we have seen. In cases like Montgomery and so on, it will not suffice. And even our own Chinbuah. Yeah, so the question is, if you have a particular thing, then I'll deal with it. Otherwise, I'll continue.
Okay, you can continue.
Okay. So what about unauthorized procedures? I call them teaching. Unauthorized procedures. So where the intervention materially exceeds the consent given, or maybe wrong site, like a surgery. You wanted the surgery was supposed to be done on the right leg. They ended up, amputating the left leg. Or sometimes even, wrong patient. They mistake patient in terms of surgical procedures. Maybe due to wrong label. The surgeon is there. In the theater, maybe they're handling about 5 or 8 cases in a session. So patient is brought. The file is there. So the surgeon will just read what is there. But those who brought the documents and other things, assuming they have made a mistake and brought information on patient A to patient C. But now we have patient C who is to be operated upon. You have a patient who is to be operated upon, and then the court, the surgeon who is at the theater will have to actually read the wrong information. So that is what we are talking about. Or maybe somebody have a steroids without the person consent. The person cannot give birth. Or transfusion against religious objection. And then also emergency, where a surgeon is conducting a surgery in emergency, he may exceed consent where immediately necessary to save a life. Again, fraud or misrepresentation may also invalidate consent and revive a battery, as the case may be. So, with respect to the scope of consent, is not unlimited. And that is why we keep saying that it has to be specific. So what exactly did the patient agree to? Then general consent forms will not authorize every conceivable intervention. Don't say that you're giving a general consent form to the person, so everything which you think should be done, the patient has consented. No. The court would examine what the patient reasonably understood. And then the scope increasingly depends on the adequacy of information disclosed, as we've seen from the cases. And ultimately now, we are in an era where patient autonomy seems to have held sway, and that defines the boundaries of a lawful treatment. Okay, I think we have to, it's 8:30, we have to stop here so that I don't overstretch myself and fall sick more. We'll continue at our next class. Unless there are questions, we'll continue at our next class.